strikingly different in its text, yet remarkably similar in its spirit, as it was when the learned members adopted it 74 years ago. The Constitution has, however, gone through 106 amendments, which have been brought forth by the Parliament in the short period since it has been in force. However, an equally intrinsic part in molding the Constitution has been played by the Honourable Judiciary in safekeeping this sacrosanct document from the overzealousness of the Parliament, thus balancing the rights of the citizen and the power of the government. The power to make law has been vested in the Indian Parliament under Articles 13 of the Constitution, whereas the corresponding power to review said law has been vested in the judiciary, considered to be flowing from a joint reading of Articles 13 and 32, as well as the doctrine of separation of powers. The power of judiciary to check legislative and executive action is thus known as judicial review. The famous tussle that took place between the two branches of the Indian government regarding the fine line between the amending powers of the Constitution and the power of the judiciary to strike down such an amendment is well known. There has been a series of judgments on the matter which form a big chunk of and are ingrained in our constitutional ethos. These verdicts regarding the balance of powers of the Parliament and the judiciary begin from the case of Sri Shankari Prasad Deo versus the Union of India and State of Bihar and continue onwards until the Ayar Coelho judgment, one of which was the historic Keswananda Bharti case, in which a bench of 13 judges sat for 68 days and finally brought forth what is known as the doctrine of basic structures. The doctrine was formulated by the learned Justice Khanna based on the foundations laid down by Justice Mudholkar in the Sajjan Singh case by reading into the concept of implied limitations propounded in the A.K. Gopalan verdict. The doctrine that thus came forward essentially allowed the Parliament to amend any part of the Constitution subject to what was termed as the basic structure or basic features of the Constitution. The case of Indira Gandhi versus Raj Narayan, better known as the election case, was amongst the first landmark judgments in which this doctrine was used, post which it has been employed extensively by courts of the country in a multitude of cases. As often is the case with a lot of landmark verdicts, the concept of judicial review too, as well as the doctrine of basic structure, has a rather complicated ratio to discern, and as such, various aspects of the judgment have not come to the fore to the extent that they must have. This has led to an irregular application and further development of the doctrine, thus leaving various facets murky and unclear. The first step in the development of judicial review was its inclusion in the Indian Constitution. The members had before them the great constitutions of US, Ireland, Japan, etc., and as such saw eye to eye on the fact that the power of judicial review needed to be more direct than in the United States, where the great havoc of judicial review was caused in the case of Marbury v. Madison. Article 13 thus unequivocally provides that the state shall not make a law in violation of fundamental rights, and if such a law is made, the courts may declare it to be void. The concept of judicial review, however, had a long way to go from the interpretation of black and white to the judiciary as we know it today. Amongst the first cases in which judicial review as a distinct part of the Constitution was addressed was in the A.K. Gopalan verdict, in which the Honourable Bench, though stating that the due process clause is unknown to our Constitution, laid down the groundwork for the further growth of judicial review. The Gopalan verdict, though overturned in the Menka Gandhi pronouncement, was the first case which posed the question regarding the concept of implied limitations and the scope of judicial review, thus laying the groundwork for basic structure doctrine. The enigma, that is the basic structure, begins with Article 368 of the Indian Constitution, which states that if any amendment, change or repeal is made by the Parliament using its amending powers, the Constitution shall stand amended. However, the Parliament, specifically during the Nehru administration, in order to meet the socialist reforms which were necessary for a newly independent India, brought various amendments and thus formed Articles 31A, B, C and the 9th schedule, which were the major points of contention in the cases involving the basic structure. 31A provided that any law pertaining to land acquisition may not be challenged if it is made in the pursuit of agrarian reforms. 31B, however, went a step beyond 31A and stated that if any law, be it passed by the state or the central legislature, is put into the 9th schedule, it becomes free from the test of fundamental rights. It further provided that even if a provision is struck down by a High Court or the Supreme Court and is then put into the 9th schedule, the struck down provision shall stand resuscitated. This amendment was challenged in Shankari Prasad case in 1951. raising, amongst others, a question that whether Article 13 would include within itself a constitutional law. A 5-judge bench, led by Chief Justice Patanjali Shastri, unanimously opined that Article 13(2) only extends to ordinary law and does not include constitutional law within its ambit, and therefore Article 31(b) was upheld. A similar verdict was the outcome in the Sajjan Singh case. However, for the first time, alarm bells were rung by Justices Modholkar and Hidayatullah, both of whom questioned the limit of the amending powers of the Parliament. The next came the much celebrated case of I.C. Golaknath versus the state of Punjab, wherein, while deliberating, there was a 5-5 split between the honourable judges, and the set of 5 judges, led by Chief Justice Subbarao, stated that the power to amend does not flow from Article 368, as the marginal note of the article reads procedure for amendment. It was further stated that the power to amend, not being located anywhere else, must fall under the concept of residuary powers of the Parliament. The other set of 5 judges said that the Article 368 is enshrined in a chapter entirely to itself, and thus deals with the entirety of powers and procedure to amend the Constitution. Justice Hidayatullah, this time being the odd man out, held that the power in question is sui generis in nature and is not found under any particular article of the Constitution. Therefore, he sided with the Chief Justice Subbarao sect and agreed that article would go to a constitutional law. Therefore, by a fractured 6-5 majority, it was held that fundamental rights are unalienable, and as such, even a constitutional amendment cannot touch them. As a result of the Golaknath verdict, the Parliament acted swiftly and brought forth the 24th Amendment, which firstly amended Article 368, provided that the power to amend ensues from it, and also secondly amended Article 13, which now stated that it applies solely to ordinary law and not constitutional law, thus destroying both the props on which the Golaknath verdict stood. Further came the 31st Amendment, inserting Article 31C, stating that any law made in the pursuance of the principles of DPSP shall not be liable to be struck down if it is violative of Articles 14 and 19 of the Constitution. Before the Keswananda Bharti bench, there was again a split, this time of 6-6, with the legendary Justice Khanna being the odd man out. It was Justice Khanna who sided with one set of judges which believed that there are some principles which are so intrinsic to the Indian Constitution that even the Parliament cannot alter or alienate them. These principles were embodied by Justice Khanna as the basic structure. Furthermore, he clarified that in order to devise such basic features, one had to look no further than the preamble, and the ideals enshrined in the preamble constitute a part of the basic features, which act as an implied limitation on the constituent powers of the Parliament. The cases discussed above, though conclude the tussle between judiciary and the Parliament in part by formulating the doctrine of basic structure, did not expound as to its nature and the constitutional location of the same. There are two intriguing trains of thought which can be found regarding the nature of basic structure doctrine. The first is grounded in Justice Matthew's verdict in the election case, and the second being laid down in Justice Krishna Iyer's opinion in the Bhim Singh Ji case. Justice Matthew felt that the basic structure must find its place in some provision of the Constitution and is not an abstract figure or doctrine as that of the supremacy of the law. Justice Iyer, on the other hand, opined that when one talks, for example, of the great egalitarian principle, it is not Article 14 that one refers to, but to the broader principle, and it is that broader principle which is a part of the basic structure. Honorable Mr. Justice Nariman, however, seems to be of the opinion that the nature of basic structure can be found using the preamble and Article 368. At the fore, I would like to clarify over here that the preamble, though being the first part of the Constitution, was formally adopted at the end by the Constituent Assembly, thus encapsulating the principles that the framers believed were intrinsic and inalienable to the Constitution. Based on the preamble, various features can be culled out, which are basic in nature, such as sovereignty, democratic form of governance based on the universal adult franchise, secularism, the republic nature, etc. Further, the proviso to Article 368 enlists the articles in order to amend which the Parliament needs consent from the states. Those articles point to the following feature, which may also be deemed to be a part of the basic structure, such as separation of powers, independence of judiciary, federalism, and various others. The question still arises that are all these features grounded in the Constitution, or are they derived by the judiciary? Justice Naribal again opined that these features are present in the Constitution. This may be said to be based on Justice Marshall's opinion in McCulloch versus Maryland, the landmark US Supreme Court ruling, wherein it was stated by Justice Marshall himself, and I quote, that we must not forget that this is the Constitution, the very fundamental document that we are deciphering and interpreting. Therefore, the general rules and norms of interpretation that apply to ordinary law cannot apply to constitutional law. Bearing the same in mind, the two visions of Justice Matthew and Krishna here may be reconciled on the premise that all the basic features are present in the Constitution, and though there may not be one article, and it might need some interpretation as such, the overall feature might not be present explicitly in the Constitution, but does emanate from an article or a set of articles. Indian Parliament, unlike its British counterpart, is not sovereign in nature, and thus follows the principle of the separation of powers and checks and balances. Judicial review is therefore an intrinsic part of the Indian legal system. Therefore, the legislature and the executive alike are held to be accountable to the judiciary. The beauty of the basic structure was that it armed the judiciary with the power to protect the Constitution during the emergency era. However, the indiscriminate usage of the same to ordinary law takes the doctrine from the settled concept of separation of powers to the domain of judicial activism and perhaps overreach, thereby going beyond the pale of the respective powers and mandate of the Parliament as well as the judiciary. I would also like to concede, however, that it is the means and the process that I am arguing over here against and not the ends. The effects aim to be achieved and the actual results of the usage of basic structure doctrine have been remarkable. The goals that were achieved using the basic structure review may have been a positive effect on the society, but the means employed by the judiciary were beyond the powers bestowed upon it by the Constitution and as such must be checked. Apart from the Indira Gandhi election case, wherein the application of the basic structure review to ordinary law was rejected by the honorable judges by a 3-1 majority, there are plethora of other instances where the courts have explicitly rejected the application of basic structure review in ordinary law. There is a hierarchy of law in the Indian legal fraternity, and the same test that is applicable on a higher law, that is the constitutional law, cannot be applicable to ordinary law. This acts as a further test on the legislative powers of the Parliament, which has not been provided for in the Constitution. Greater the power, the higher must be the test, and as such, the yardstick by which constitutional amendments are judged cannot be used to check ordinary law. Furthermore, constitutional judicial review can only be used to strike down ordinary law made in furtherance of legislative powers under the Constitution if it violates any provision of the Constitution. Basic structure, being devoid of any explicit provision, cannot be used to strike down an ordinary law. In addition to the same, the argument behind the inception of the doctrine was the concept of implied limitations. The learned judges believed that there are certain aspects of the Constitution and must not be destroyed, and as such they act as an implied limitation on Article 368. One of the most famous examples that was given by Nani Palkhivala himself was that tomorrow, for example, if the Parliament were to bring forth an amendment that removes the office of the President, the same cannot be held to be within the pale of its powers, because it is not possible that the Constituent Assembly thought of the same and envisioned that when they provided for Article 368. Similarly, it stands to reason that the powers of judicial review must, the two, being a part of the Constitution, is subject to certain limitations, both express and implied, and the application of basic structure doctrine to ordinary law goes against both of them. There are various suggestions that I believe may be applicable in this particular case. The features which comprise the basic structure may be deciphered from the preamble and Article 368. However, there are various such features which cannot be as easily found in the constitutional provisions. However, if all such features are grounded in the articles themselves, that the normal constitutional review must suffice as a check enough on the legislative powers of the Parliament. Further, various basic features have been laid down by the judiciary which are not very clearly or explicitly present in the Constitution. Such features, though vital, can be pulled out by the judiciary as it deems fit. However, testing the legislative powers on the features that may be devised and stated at any point, using a power that has been devised outside of the bare text of the Constitution itself, seems an excessive use of judicial review, in my opinion. However, in the Ismail Faruqi case, better known as the Ram Janmabhoomi case, wherein a statute which abated suits and other legal proceedings against the disputed sites was challenged, and the legislation was struck down on the grounds that it went against the basic feature of rule of law. It is a matter of no contention that the Impugned Act, which singled out a particular dispute and prohibited any legal action in the matter without any alternate dispute mechanism, was unfair and against the right to equality. However, the same legislation could have been invalidated on the grounds of it being violative of the concept of secularism alone by means of making the preamble enforceable. The same goal could also have been achieved by striking down the legislation on grounds of it being in contravention of Article 14, the right to equality, as it singled out one particular dispute for the removal of judicial remedies. Similar outcomes have been reached in various other verdicts as well, which use basic structure doctrine to test ordinary law. However, as stated succinctly in the Bhim Singh Ji case by Justice Chandrachud on behalf of himself and Justice Bhagwat, but to permit the Bharati Ghosh to haunt the corridors of the court, brandishing fatal writs for every feature of inequality, is judicial paralyzation of parliamentary function. Nor can the constitutional facilitation for the basic structure doctrine be made a Trojan horse to penetrate the entire legislative camp fighting for a new social order and to overpower the battle for the abolition of basic poverty by the basic structure doctrine missile. The bench in Kuldeep Nair case, another case which denied the application of basic structure doctrine to ordinary law, based its reasoning on the majority opinion in the election case. The 3-judge majority verdict of election case thus stands absolute, as none of the judgments that go against it are pronounced by a bench of equal or higher size. None of the learned judges who have opined in the favor of the expanded scope of judicial review have attempted to distinguish from the view in the election case, thus making those verdicts per incurium and liable to be held bad in law should the same question arise again. The courts may declare in clear and unambiguous terms that the inclusion of ordinary law within the scope of basic structure doctrine is beyond the intended mandate of the Constitution as well as that of the jurists who helped formulate it. The view of the Constituent Assembly has long been considered as indicative of the intent of the Constitution, and the same must not be ignored by the judiciary when adjudicating upon the limits of its own powers. The instances of the application of doctrine to the ordinary law must be struck down or deferred from as being ignorant of the judgments of benches of highest strength as well as the constitutional provisions. As such, it is not being argued that the application of the basic structure doctrine to constitutional amendment must be curbed. However, its expansion to include ordinary law within the scope of its application seems at odds with the great legendary stalwarts to whom the same may be attributed: Justice Khanna, Justice Mudholkar, Dieter Conrad, and the legendary Nana Bhai Ardeshir Palkhivala. Thank you.